welcome to The Explainer. Today, we're digging into a really fascinating patent law case. It all comes down to just a few crucial words, and it led to a surprisingly split decision from a major federal court. All right, so how does this even happen? Let's dive right in. We're looking at the case of Net MoneyIN versus VeriSign. And in this case, the court basically struck down huge parts of a patent, but then saved one little piece from the legal scrap heap. It's a story about the rules of invention and, what it really means for an idea to be new.
So first, let's set the stage for what is basically a legal detective story. The details here really matter, because they paint a picture of how innovation was all unfolding in the early days of the web.
Okay, so this whole thing goes way back to the dawn of e-commerce. Think about it, 1996. An inventor, Marco Graham, sees this growing problem. Customers were having to send their confidential credit card info over the internet to merchants they barely knew. So he designed a new, more secure system and filed for a patent. Fast forward a few years, and his company, Net MoneyIN, starts suing competitors like VeriSign, basically accusing them of using this patented method without paying for it.
Now, at first, things looked really bad for Net MoneyIN. The lower district court just threw out all their patent claims, sided completely with VeriSign. But then, on appeal, something really interesting happened. The appeals court agreed that most of the claims were invalid. You can see that here. They affirmed the decision. But, and this is the big but, it reversed the decision on one specific part, Claim 23, and breathed new life into it. So this creates our central mystery. Why were some parts of the invention totally invalid while this other one was saved?
Okay, let's tackle that first mystery, the parts of the patent that got struck down for good. And the problem wasn't really the idea itself, but, well, how it was described.
The whole issue came down to this legal concept called a means plus function claim. Look, in simple terms, it's when you try to patent something by describing what it does instead of what it is. It's kind of like patenting a means for baking a cake, but you never actually include the recipe. And the law is super clear on this. If you're going to do that, you have to provide the recipe, the specific structure or algorithm somewhere in your patent's description.
And that is exactly where Net MoneyIN's patent fell short. It claimed a means for generating an authorization indicia, a fancy way of saying an approval code that would happen on a bank's computer. But the patent never actually explained how the computer would do it. There was no algorithm, no flowchart, no specific instructions. It was just too vague.
And this quote from the court's decision just nails the point. You can't just say a computer does it and call that a structure. I mean, a general-purpose computer can do anything. To get a patent for an invention that runs on software, you have to disclose the specific software, the algorithm, that turns that general computer into a special-purpose machine, one that's designed to perform your unique function. Without that blueprint, the claims are just indefinite and invalid. So let's move on to the second, and I think more dramatic, mystery. How in the world was one claim rescued from all this? This part of the case is all about what it means for an invention to be truly anticipated by earlier work. So how did Claim 23 survive? Well, VeriSign's big argument was that it just wasn't new. They pointed to this 1995 document, the IPAK reference, which was basically a technical guide for early internet payment systems. VeriSign's lawyers argued that this single document contained all the individual components of Net MoneyIN's invention. In other words, the cat was already out of the bag. And the lower court totally bought it. They went on this sort of scavenger hunt through the IPAK reference, just like you see here. They found one piece of the invention described in one payment model, another piece in a second one, and then the rest were scattered elsewhere in the document. Since all the parts could be found within the four corners of that one paper, the court said, yep, patent invalid. They called it anticipation. But the appeals court just slammed the brakes on that whole line of thinking. They said, whoa, 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 that is not how anticipation works. You can't just find all the Lego bricks scattered in the box. To anticipate a patent, you have to find the complete, fully assembled model, exactly as it's described in the patent claim, all within a single coherent example in the prior art. And this correction from the appeals court is so important because it highlights a crucial difference in patent law that the lower court just got wrong. A distinction that is absolutely vital for any inventor to understand. So the district court confused two totally different legal tests, anticipation and obviousness. Think of it this way. Anticipation is the smoking gun. It means the exact invention is already laid out fully and completely in one single place. Obviousness, on the other hand, is more like connecting the dots. It asks whether someone with skill in the field would have found it obvious to combine different ideas to create the invention. VeriSign was trying to prove anticipation, but the way the lower court reasoned,
It looked a lot more like a failed obviousness argument.
So, the whole thing comes down to this one legal phrase that not only saved NetMining's claim, but also gives us the biggest lesson from this entire case.
And here it is. This is the core lesson of the whole case. Anticipation is not a scavenger hunt. A piece of prior art has to disclose every single element of the invention, and, this is the critical part, it must disclose them arranged as in the claim. The blueprint has to be intact. It has to show not just all the puzzle pieces, but the pieces already put together in the exact same way the invention claims. Because the IPAK preference didn't do that in any single example, it couldn't anticipate Claim 23. Simple as that.
So ultimately, this case is a huge protection for inventors who create a new system by cleverly combining existing ideas in a way nobody has before. But it also leaves this critical legal question for every inventor and tech company out there to think about. Is your idea truly a new arrangement, or is it just an obvious next step? As this case shows, the answer to that question can be worth millions.